drying racks. There's a new law that's effective, I believe, January 1st, 2016, which permits owners in HOAs to use clotheslines and drying racks. There's a separate provision in the law that's similar to tenants. In essence, the law makes void and unenforceable any HOA governing documents like CCNRs that effectively prohibits or unreasonably restricts an owner's ability to use a clotheslines or drying rack in the owner's backyard.
Not condominium.
Correct. So,
Can I hang
so
my
let me-
underwear on the balcony?
so this is what I'm getting. So this law only applies to backyards that are designated for the exclusive use of the owner. It excludes a balcony, a railing, an awning, or other parts of a structure or building. So if you have a private balcony, you can have a clothesline or drying rack. If it's out in the open on your balcony, it's an eyesore, and
What if it's a
don't do
patio?
it. I'm
Like a
sorry?
Front courtyard patio.
If it's visible, I mean, it talks about backyard. If it's visible and open, probably not. But they haven't clarified that. It only talks about backyard, but, if it's an eyesore, do you really want it? Yes, Jill's?
Do you know that long time ago, it's in the CCNRs for each lot in the valley, that when they built, it was the property line. There was no fence. It was a clothesline. You know that?
No, I didn't know that.
Yeah.
And that's involving a HOA or,
So everybody had the clothesline.
Okay, Jill, it's a little off topic.
No, it's in the CCNRs.
I understand. Okay.
okay, so another common
That's the
interest.
property line.
So
Got it.
here, especially in the valley, we're experiencing a lot. Well, in California, we're experiencing drought. So now, another law that just passed, effective September 9th, this law makes void and unenforceable common interest development prohibitions against the use of artificial grass. So what it does is it makes any provision of a homeowner's governing documents or architectural or landscaping guidelines or policies that prohibits use of artificial turf or any other synthetic surface that resembles grass. It also prohibits a requirement that an owner of a separate interest remove or reverse water efficient landscaping measures. For those who own rental properties or who may manage rental properties, this may affect you. So landlord and tenant mold issues. So there's a new law that says that a landlord is not obligated to repair dilapidations relating to mold if, number one, until he or she knows or has notice of it, and number two, if the tenant fails to keep the property clean and sanitary and thereby substantially contributes to the existence of the mold. So for a building or a portion thereof to be declared a substandard building by virtue of mold, it must be visible mold growth as determined by a health officer or a code enforcement officer, which endangers the health of the occupants. If the presence of the mold is minor and found on surfaces that can accumulate moisture as part of their proper and intended use, that would not constitute a substandard condition. Finally, there's another law that affects landlords and tenants. It's the victim's right to terminate tenancy. And this is effective until January 1st, or effective January 1st, 2016, extends current law indefinitely to allow a tenant to terminate a tenancy if he or she is a victim of domestic violence or sexual assault. And it also reduces the termination notice period from 30 days to 14 days. So what it means is that it authorizes a tenant to notify the landlord in writing that he or she or a household member was a victim of domestic violence, sexual assault, stalking, even elder abuse, or human trafficking, and that tenant intends to terminate the tenancy. The tenant is required to attach the notice with a copy of the temporary restraining order or protective order that protects a tenant or household member from further domestic violence, sexual assault, stalking, elder abuse. Yes?
What's protective order?
So usually if someone's harassing you, like someone's stalking you, now you go to the court, or you have a husband. Sometimes we see this more in domestic disputes. So you have a husband and wife, and the husband is beating on the wife. The husband goes to the court and petitions the court for a TRO, a temporary restraining order, and that on domestic abuse cases is usually granted if there's like a police report showing that they've been abused before. And once the temporary restraining order is granted, within about a month or so, they can apply for a permanent order, so prohibiting them from being like 100 yards, from the spouse.
So just the police order won't do, it has to be restricted?
Yes, has to be a court order, court protective order, or a temporary restraining order from the court. Yes.
So it doesn't have to do with if it happened on the property or not. It has to do with if they've just been a victim of an assault, as referenced here. They can give you 14 days notice and leave.
And that's the thing with this new code section. It's silent as to whether or not it has to occur on the premises. But I think that, I think the goal was to make sure if the tenant feels unsafe and they're a victim of abuse and the perpetrator knows where the victim lives, they could probably escape any repercussions. Go ahead.
Does this apply strictly to residential, or is it also commercial?
Residential. Okay, so that's pretty much it with respect to the new laws. I'm moving over to the fundamentals of practicing real estate and trending lawsuits. I'm going to talk about documenting your files, contracts, disclosures, contract formation, and recent lawsuits. Okay, so documenting of files. Rule number 1, if it's not in writing, it didn't happen. Rule number 2, see rule number 1. I mean, I'll tell you, I get a lot of lawsuits involving these issues. For example, you have a prior report, or either a home inspection report from a prior escrow, or a geo report from a prior escrow that failed, and then you have buyer number 2 come in, and you give them these reports, but you don't have a signed receipt. There's a CAR form with a receipt for reports, and you don't get that signed. And down the road, when the buyer closes escrow, buyer number 2 closes escrow, and they find that, oh, there's a geo issue with the property. And you're like, well, I gave you this geo report. Well, how do you prove that? And that's what makes my job difficult if you don't have a signed receipt, and makes your job difficult to get out of this lawsuit as a defendant. So make sure
Email is enough to prove, right?
email is good to make sure you put that in the file, and then make sure the email is fairly specific as to what document you are providing or what disclosure you're trying to make. But let's be clear though, I wouldn't use an email to amend a TDS. You're in escrow, you already provided a TDS, something happens, or there's a new material fact that you discover 10 days later after you've provided the first TDS, you want to make sure to amend the TDS. And does anyone know why that's significant to amend your TDS?
This
Yes.
makes the clock start over again at the time of review?
Correct. What it does is it gives the buyer another 3-day right to rescind the escrow, based on the disclosure or the amended TDS. So that's why it's significant to make sure you document your files and provide the required disclosures.
Wouldn't the receipt for reports suffice? Or you think it should be an amended?
Well, it depends on what you're trying to disclose.
Well,
If it's you're
giving them
disclosing
a geo
information
report-
you heard from a neighbor, that wouldn't be a
I'm
prior.
talking about what you're saying, you had a geo report.
Correct. A geo report, yeah. Please put that in the receipt for reports.
But that's not a TDS item,
Correct.
right?
Well,
Oh.
that's what I'm saying.
Yeah. Okay. Yes.
If you've done the TDS and declare that because it wasn't something?
No, not necessarily. When you look at the RPA, and I forgot which paragraph, but it talks about you don't have to amend the TDS if it's disclosed within a report that was generated by the buyer during escrow. So you don't have to continually, amend the TDS with respect to that issue. But there's a specific provision in the RPA on that very topic. So going along with the documentation of files, you got to make sure to help Stuart out here. I mean, as a broker, Stuart has his own obligation. And the broker, it says under BRE Regulation 2725, for those that can't see the screen, that the broker shall exercise reasonable supervision over the activities of his or her salespersons. Reasonable supervision includes, as appropriate, the establishment of policies, rules, procedures, and systems to review, oversee, inspect, and manage. Number 1, transactions requiring a real estate license. Number 2, documents which may have a material effect upon the rights or obligations of a party to the transaction. And number 3, filing, storage, and maintenance of such documents. We all know that the business practice, you want to develop a business practice of documenting your files. And this includes having file jacket notes, putting letters in your files, diaries, and logbook. So for me as an attorney, I actually really stress on having a logbook, a conversation log or telephone log. So every time you pick up the phone and speak with your buyer or seller about a certain aspect of the transaction, take copious notes, and keep that in your file, because sometimes there could be something in there, like for example on 11/11/15, I spoke with the buyer about the home inspection and pool leaks. So down the road, if there's ever an issue about ever speaking with them about pool leaks, you have that in there, in addition to hopefully your TDS. That's a pool leak issue.
But it by itself is not binding in any way.
No, but at least it would assist us and you to say, hey, this actually happened because it's in my logbook. It's my telephone log. For example, you didn't provide a TDS for the pool leaks. And you say, I spoke with the buyer about this pool leaks, and I don't have anything other than my phone log. Well, I'd rather have a phone log with that entry than just your word saying I spoke with them. Yes?
If you keep it on your phone, it's not enough?
And I'll get to that, but I think that if you have a text, print it out and store it and maintain it with your hard copy of your file. I don't know if Stuart has everything digitalized, but great, Stuart says he does, and so it would be great to print it out when you can and then put it in your file.
Yeah, well, just a quick note, just very quickly. Okay, so every file has an email address as well within our paperless pipeline. So you can use that email address to CC or BCC every email that you send. It just sits in the file and basically it's just there for your purposes. You can also, for that same email address, any document that goes back and forth automatically goes into paperless pipeline, and then you have the choice of whether you're going to keep it or not. So as things progress, if you'd like to utilize that, we have our TC, which will go ahead and document that as well. And also for your telephone notes, if you go ahead, and some programs will be there where you can just basically hang up the phone and it pops up and says, what was your conversation about? Or send a little email to yourself, just documenting I spoke to them.
Great, Stuart, thank you for that. So going along with saving emails, that should obviously be a practice of yours. Print out emails or digitally store your emails. for later use. Faxes, obviously. Even things that you wrote down on a cocktail napkin, anything that would help document your file and prove that the conversation actually happened. Let me ask you this. We talked about texts, but do you think tweets, should you be saving tweets? Anyone? Stuart?
If it happened, save it.
Exactly. A good practice is to save everything. You never know whether that one piece of document will absolve you from liability. Conversely, don't bury bad notes. For example, you talked about this pool leak, but it was, you didn't disclose it properly, or there was other issues about the pool leaks that you didn't provide to the buyer how extensive it was, and the buyer ends up buying the property and he has a huge pool leak, now a structural issue with the pool. Don't try to bury that. That's obviously fraud. Okay. So we talked about the legal requirement to preserve your files for 3 years. And I always get the question, well, should we, everything's digital, should we preserve our files for a longer period than 3 years? And I say, you know what? That's a double-edged sword. And that's up to your broker to decide if they want to hold the file for longer than 3 years. And let me give you an example of a real lawsuit that I've had before. So the broker, let's say 10 years ago, was sold the property to the buyer, and there was a bad report in there. I'm going to say bad mold report in that, and the broker had it on digital, a digital file, and had it saved. So 10 years later, that seller ends up selling to another buyer, different agents. The agent was no longer there, so different agents, but the broker still had that mold report. But the new agent for this buyer and the listing agent didn't know about the existence of this mold report, and they ended up selling the property to buyer number 2 without disclosing or providing that mold report. And down the road, this buyer discovers that the inside of the walls was filled with mold. And they ended up suing the agent. The agent said, I don't know anything. They subpoena the broker file. The broker file, they look through it. Stuart is a fair and honest guy. He says, well, it's in here. He gives it up during the subpoena, and then now and behold, we have a smoking gun. So you're supposed to provide that if it's in your possession, custody, or control. So the flip side is,
destroy it then.
yeah, I mean, the moral of the story, yes, you can destroy files within 3 years, but the flip side to that story is, how about if you have something that absolves you from liability and you threw it away? So again, this is a slippery slope, and this is obviously.
After 10 years, is there another statute of limitations in regard to, let's say, the office?
So statute of limitations for a breach of contract, just so you know, it's 4 years. Statute of limitations for negligence and a broker, broker negligence and failing to spot something on the wall, or that's 2 years. Statute of limitations for fraud is 3 years, but the kicker with a fraud cause of action is it tolls. It tolls from the date of discovery. So it can go for 5 or 6 years, but then, and you figure, oh, I'm safe, but no, if the buyer discovers a fraud on the 6th year, he still has up to 3 more years after that to sue you for fraud. So.
Well, in this case, are they suing for fraud, the mold issue?
Yes, they're suing for fraud, but I think that's a harder case. I think it's going to be general negligence, imputed knowledge from the broker, and that's what, and I think that'll be our next Supreme Court decision down the road if someone ever took it up that far. Contract formation, should be all pretty basic to most of you guys. Make sure you fill out forms completely. obtain your client's signatures timely. You know, if you have a husband, I just had a phone call yesterday on a risk management issue. It's a husband and wife, they're on title, and the husband doesn't want to sell, the wife does want to sell. Can you list the property?
Yes.
Well,
No, you need signature.
if they're both on title to the property, who do you need the signatures of? Both.
To
If-
sell.
To sell. Unless you have a court order that allows you to force the sale, you need both signatures. And without that, you can't even get a listing agreement. So, food for thought. And the follow-up question to that, well, how can, and they were going through a divorce. And out of the country or something, in China. And, well, how can my wife sell this property? How can I help her list the property? I said, look, the only way to get the listing is if you get the husband to sign it, or the wife hires a lawyer here in the United States, files a partition lawsuit. A partition lawsuit forces the sale, and that's a court order, and it allows them to, you know, obviously get a listing agent and sell the property, and then they divide the proceeds accordingly. So that's, make sure the signatures are dated after the close of escrow or ineffective. So make sure you always date things before close of escrow. Never backdate signatures. And that's especially critical on like a TDS.
So how do you do that?
Well, people have done it before. Obviously, everyone uses zip forms.
Sometimes you miss a spot and then you have to sign it after you close. You're actually backdating. But
No, I understand that. You know, and it happens, and you just make sure if you have to backdate for whatever reason, you make sure to let the principals know that you're backdating because you just, you
Missed
know, you missed it. It's just housekeeping. And if it's not a critical form, it probably wouldn't matter per se. But if it's a critical form like a TDS, you definitely got to let the parties know what happened. Reduce all terms to writing. Review each and every paragraph with the client. And, you know, I had this one case where the buyer ended up suing us because our agent didn't recommend a geotech. And so I asked the agent, well, did you provide this buyer the buyer's inspection advisory? Yes. Well, let me back up. On the TDS, the listing agent disclosed numerous cracks at the property, buyer to verify. So when the buyer asked our agent, what should I do? He goes, well, your home inspector should be good enough. You know, didn't recommend anyone else. And so when I got the file, I was like, oh, okay. Agent client, did you go over the BIA with the buyer? Yeah, I went over the BIA with the buyer. Well, you know, in the buyer's inspection advisory, when you see cracks like that, you know, automatically in my mind as a lawyer, I think structural, I think geo. So I'm reading the buyer's inspection advisory to this client agent. I said, see here, it says buyer broker recommends a geotech engineer. What's that? You know, the guy's never heard of a geotech, never advised the buyer properly. So in this case, if you don't know what you're reviewing with your client, or you don't know anything regarding any portion of a contract, make sure you ask your manager first before you start speaking with your client, or don't just give it to your client and expect them to understand everything that they read and sign. So, just a backstory. Acceptance must be unequivocal. You have to be available to receive acceptance or counteroffers. Extra care is needed in multiple offers. Be liberal with additional terms to the contract if needed.
What did that mean?
Be liberal with additional terms to contract if needed. So if the buyer wants to add additional terms to a counteroffer, and let's say seller to accommodate buyers 1031 exchange or something like that. You know, that's a fairly reasonable request. You don't want to advise, as a listing agent, advise your seller, don't accommodate that buyer. So something along that's reasonable and pretty much normal in some situations, go with the flow, but obviously, ultimately, it's your seller who's going to make that determination. Yes?
You say if they'll review each and every paragraph with the client. These days, using DocuSign, people don't read anything.
Yeah.
You know, any suggestions?
Oh,
Well,
I have one
you know-
suggestion, can I say something? This is really, because of DocuSign, one of my clients thought that they had sold the house for 1,325,000. But actually, it was 1,300,000. So when we came to ask to sign the papers at the end, they told me, oh, Rita, we thought that we got 1,325,000. I said, don't you read your papers? But because of DocuSign, people tend to rely on you, and so from now on, I'm texting also, especially this purchase price.
Correct. I mean, and that's a problem with some technology. They don't go back and read everything. And it's hard to sit down with a client and actually go over everything. But if you can, I mean, this is
Yeah, and I
just
have
this is just my general practice for you. And I understand in the real world, it may be different to accomplish all these things. But to the extent that you can, try to do that. And you're right about documenting everything. Send them an email to make sure, hey, these are the price points of the purchase agreement, so you understand that there's no mix-up. Because I did have a case where an elderly lady thought she was buying Unit A, but she ended up buying Unit B in a condo, and then she ended up suing everybody. So,
Oh yeah, my suggestion would be if you get your client on the phone after or before they've DocuSigned, you can get them to download the PDF and scroll through it, and you can describe at least the key paragraphs and what they mean before they go click, 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 because it is amazing. It just jumps from signature to signature, and you don't see a thing.
so let's go to disclosure fundamentals. I mean, I can't stress this enough. I would say a good 80% of my cases involve disclosure problems. And so disclose, don't investigate. I always say disclose and refer to appropriate professionals. Under California Civil Code 2079, an agent has a duty to competently and reasonably inspect and do a diligent visual inspection of the accessible areas of the property and to disclose to the prospective purchaser any material facts that affect the value or desirability of the property. So what does that mean? I'm going back to 101. Accessible areas of the property. Do you have an obligation to inspect the attic or crawl space?
No.
Good. Unless you're a home inspector and you're ready to put on your jumpsuit, don't do that. You know, it's normally not accessible, but I've seen sometimes where the attic is accessible. It's just like a staircase right into it, but even then, that's iffy. If you're selling a condo unit, are you obligated to inspect the common areas?
No.
No.
Right. You're not obligated to inspect the common areas. Your only obligation is to visually inspect the unit up for sale. However, if someone, tells you about there's a problem with the common areas or problems with the parking, you got to disclose that. You don't have to go and investigate or inspect those areas. You just have to disclose that on the TDS about whatever someone told you about those other issues. Fiduciary duty, everyone knows that you have a fiduciary duty to your client, either buyer or seller. You must put your client's interests ahead of your own. Depending on the circumstances, a fiduciary may have the duty to investigate further. They may not accept information from others as being true unless the disclose to the principal that the information has not been verified. that you identify the source of the information so that the principal knows it's merely being passed on. So if you got something from the listing agent about the square footage, you know, it's 500 square feet less, disclose it to your buyer, say, hey, they say it's, you know, the property's 500 square feet less, but you should verify that with your own appraiser or contractor to do measurements of the property. You limit the scope or nature of your duty, put it in writing again, everything in writing. If you know of any past or present litigation involving the property, make sure you put a little note on the TDS. Hey, there's current litigation, or there was a past litigation involving construction defects on the HOA or the specific property, and give as much information as you can about that lawsuit, by the case number or attorney's name. And you also want to explain the contract terms and disclosures, even if those were sent by the escrow. One of the most horrendous case I've ever had dealt with a short sale. You know, there was a buyer, there was a seller who was underwater, and reached out to the listing agent and said, can you help me short sale my property? I can't afford this, and it's worth $300,000 less than my loan. So the listing agent says, yeah, I can help you. So I'm simplifying this for everyone. The listing agent was able to speak with the loss mitigation department and informally said, yeah, if you can get me $500,000, I could probably get it done for that price. So they were looking around, they marketed the property. They couldn't get it done for $500,000. This is a Bel Air property. They couldn't get it done for $500,000, or couldn't find anyone to purchase for $500,000. So the listing agent, what they do during their 6-month listing period, the listing agent goes to the loss mitigation department and says, I'm going to buy it. And the listing agent purchases the property, obviously without disclosing it to the seller, and thereafter evicts the seller from the property. All this during the listing period. You know, obviously the seller sues us and says, hey, you breach a fiduciary duty, fraud.
That's true.
And I said, I called the agent, I said, my client, I said, what were you thinking? Why'd you do this? He goes, well, I was being nicer than the bank because I let them in the property for 2 months longer without evicting them than a bank would have. That was their excuse. No remorse whatsoever. And obviously, I told the broker, you got to terminate this agent. You know, we got to settle quick. We got to settle fast because you don't want to take this to trial. You'll get punitive damages. And by the way, I think most of you know, your E&O coverage does not include fraud. So if you ever get hit for fraud or punitive damages, that's on you. So I know all of you guys here aren't like that. So let me talk about some of the disclosure lawsuits that I've had. Does anyone think that should you disclose the existence of wildlife?
Yes,
Any hands?
yes.
Okay. So existence of wildlife, should you disclose that?
That bobcat in that backyard's a big problem.
How about peacocks? Should you disclose peacocks?
Yes.
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 Okay, so I'll tell you a lawsuit I had involving a property in Palos Verdes. There's 2 areas in Palos Verdes that are notorious for having peafowl, and that's peacock and peahen. One is Malaga Cove, the other one is Espinosa Circle. So this property was in Espinosa Circle. It was a probate sale, a death in the family, and the TDS, it says peacocks in the neighborhood.
There's a TDS.
Yes, there was
Even
a
though it's a
TDS. Yeah, it
probate.
was a TDS. Or it was some sort of disclosure. I don't know if it was a TDS because that's exempt, but there was some sort of disclosure that says peacocks living in the neighborhood. The buyers, both attorneys, purchased this property. And then, about a year later, the agent and the broker get sued because based on the peafowl. And so I'm taking this guy's deposition, taking husband's deposition. I'm like, sir, did you read this disclosure or this letter saying there's peacocks or peafowl that live in the neighborhood?
What is peafowl?
Peafowl is the generic name for the peacock and peahen. So
Oh, peahen. Okay.
you know, because peacock, obviously male, peahen, female. And so, you know, yes, it was disclosed to me that peafowl live in the neighborhood. What wasn't disclosed to me that at 2 o'clock in the morning during mating season, it's and I can't go to sleep. They're a nuisance. And in these areas where there's a lot of peafowl present, there's pro-peacocks and anti-peacocks. And so later on I learned, this lawsuit eventually was dismissed.
Thank God.
But, you know, I later learned that the wife was the one who was initiating this lawsuit. Because I took her deposition and I said, well, when you learned that peacocks were doing this, what did you do initially? Well, I went to the city, and the city said, they'll give me a trap, and they said you could trap 50 birds and we'll relocate these birds for you. I said, okay, fine. So she trapped the 50 birds. And then the city took out the trap. She still wasn't happy that she was able to relocate 50 birds. She went to Home Depot, bought her own materials, and made her own trap. And she started trapping birds illegally. Well, the pro-peacock neighbors found out, reported her to the police and to the newspapers, and then she was in the news as, you know, illegally trapping these birds. But so it was her ego that initiated this lawsuit. But in any event, yes, you do have to disclose the existence of wildlife. What about paranormal activity? Do you need to disclose that?
Yes.
Oh, yes, you disclose everything.
Okay. Yes.
You know about it. Dead people, is it 1 year you have to disclose or?
Within 3 years of the death, unless it's, you don't have to disclose that it was AIDS or something, but it's a 3-year requirement.
In the house?
In the house or around the house, it could be the pool.
Yeah, well, on the property.
Yeah.
3 years, I
3
think
years.
1 year.
3 years.
3 years. And so, let me give you an example of a paranormal activity. I mean, this is a true story. I'm not making this up. A manager from the Studio City office calls me and says, Jose, I've got this interesting issue. I said, okay, well, what's going on? Well, we just got this listing, and the listing agent just told me that the contractor was elated to finally finish his 3-week project, the property. I'm like, well, what do you mean? He goes, well, the contractor told the listing agent that during the 3 weeks he was at the property, he was by himself, doors were opening, closing, and his tools were being moved around. He goes, do we need to disclose this?
Yes.
I said, well, you know me, I always want to disclose everything. I don't want you to get into this lawsuit. So yes, you got to disclose it. Okay, I kind of feared you'd tell me to do that. But how do we disclose it? And I said, well, on the TDS, be matter of fact about it. So per contractor, doors opening, closing, tools being moved. Something along those lines. Just put that out there. Don't opinionize it or anything else. Just put that as a matter of fact. So they get into escrow with this buyer. And the buyer sees this TDS and says, you know what, I don't believe in this BS, but seller, let me spend one night at the property before I close escrow. And the seller says, oh, okay, fine, go ahead. So the buyer spends one night at the property and is never to be heard from since. No, I'm just kidding.
Disappears.
The buyer does spend one night at the property, but then the next day cancels escrow. And then they ask him, well, why are you canceling escrow? He goes, well, during my stay there, I was by myself. Doors were opening, closing, and my things were being moved around. So,
This is time to call one of those TV shows.
Ghostbusters or
It was a friendly, helpful.
Ghost Adventures, something. So,
All right, so now do you have an additional disclosure because of that? Somebody stayed in the
Yes.
house and also
So,
yeah, I think so. I mean, you just have to put it out there. You know, I never followed up to see if they actually eventually sold that property, but I'm sure they did.